That's what these are doing. They are interfering in, if you like to use that word, in the private sphere. And there are provisions on equal pay for women where you imply into every contract an equality clause so as to guarantee equal pay for men and women. That's the way it works. And if you look at Judge Palmer's long and comprehensive volume of cases, there's a particularly interesting one that goes back to what we were discussing this morning about the private sphere. Toward the end of this volume, there's a case with an unpronounceable name of Sidabras and somebody or other against Lithuania. And the interesting thing about that relatively recent judgment is that this is about a former KGB officer who is banned from basically civil service employment because he was a KGB person in Lithuania. And what the Strasbourg court focuses on is that he was also banned from private employment. And they say that a state-imposed restrictions on a person's option to find employment with a private company for reasons of lack of loyalty to the state can't be justified, that they might be in the state. So there's an example of the Strasbourg court, like our statute, insisting that the concept of non-discrimination must go beyond the public sector and apply to the private sector. And then we have all these private schools, private companies, the private sector generally, and it's only in very, very rare situations, like a landlord with a room in his house, or a very, very small employer exception. Otherwise, the private sector, all of this reaches into the private sector.
Then we had the presentation from Lord Walker, Judge of the Supreme Court of England. He discussed 3 cases in particular and how the problems came up concerning discrimination. The person was claiming pension, person was claiming compensation, and a person who was claiming admission to a Jewish faith school. There were questions asked by many participants whether Sridhar Rao compared the Indian and the European situation. Sister Roshan Darvi drew our attention to the requirement of an affirmative action. Then Justice Muralidhar referred to the issue of proportionality, and he particularly drew attention to a particular case and the law which says that, well, women can't have a right to elect if they have more than 2 children, and that legislation having been upheld by the Supreme Court. Then Brother Waghela, he spoke about the issue of giving less payment in a government job where it is being given as a sort of a largesse. Well, we have that problem on hand, and in fact, as you all know, the recommendation has been made to the government that there should be equal pay even to the persons working in the employment guarantee scheme, and the government is explaining its own difficulties. But you may remember that there is a judgment, earlier judgment, in the Delhi horticulture case by Justice Sawant, and the approach where employment is provided in an employment guarantee scheme and the other employment is a different approach. That is the law laid down by the Supreme Court, and there you can't bring in ideas of minimum wage. That has been the judgment. And then Lord Lister referred again to the problem, and he said that, well, Indian judges are perhaps a little more active and going into area which they are not expected to go. But I may remind him, recently there was an article in Economist which says that, well, in England also this is happening, and it was stated that citizens prefer a determination by the judges more than a determination by the legislators. That was an article in Economist very recently. Brother Jayant Patel, he referred to the problem of different students from different religious backgrounds studying in the same school and the problem arising therefrom. And then again, Lord Lister referred to the responsibility of a marriage registration officer, where a marriage of two persons belonging to the gay community is to be registered, and it is required to be registered. It is the responsibility of the officer, he can't discriminate. Then we heard Mrs. Justice Elizabeth Palm from the European Court of Human Rights. Well, remarkable judgments have been given by the court, and it was being stated that maybe the Indian participants may not have anything to do with that. But then, as Mrs. Justice Palm herself stated, that many of the principles which have been laid down, they are being looked into by the courts outside Europe. And I do feel that the judgments and the situations which are dealt with in Europe, maybe not today, but they are surely going to arise in India shortly. Because we have a variety of diaspora in India, variety of problems, and so many of these situations will be coming up. And then we had, of course, the ultimately the lively discussion with respect to the jurisdiction of the Luxembourg court and the one in Strasbourg. And with that we conclude. Thank you very much for all the participants. I'll be leaving you. I won't be there in the afternoon, so I thank Mr. Gonsalves and all other organizers for inviting me and to be over here. Thank you.
That's okay. Thank you very much for coming and chairing the session. We're running half an hour late, so the session will start at 2:30. In the evening, after the session concludes, there's a tour of the Nehru Memorial, which is the place where Jawaharlal Nehru, our first Prime Minister, resided. It will start at about 6 or so, just after the session ends, and will carry on for about 45 minutes. In your pack, you will find a CD of the advocate called The Advocate, and it's a little unorthodox that we put it into your pack. He was one of India's finest human rights lawyers and a dear friend of ours who fought for the rights of prisoners all his life, and he died a couple of months ago. And we were fortunate to actually do a very, very lengthy interview with him about his life and his times before he died. You might find it very interesting to see this. Our publications are outside, so as you leave, you'll see all the publications of the Human Rights Law Network on the right to food, the right to health care, on prisoners' rights, on disability law, and so on. So you're welcome to take whatever you like. So lunch is just downstairs. Thank you.
I spoke to him about and said I was going to talk to him.
A very, very hearty welcome to the distinguished galaxy of judges from the United Kingdom and states, various high courts from the country, as also the learned participants in this today's subject of great relevance and value. We are all aware, and I don't think we need to inform ourselves, that the Indian Constitution, as also the United Kingdom, we are committed to the eradication of discrimination in any form. The Indian Constitution, as you are all aware, that it envisages not only in its introductory preamble to abolish all sorts of discrimination. We have a specific article where we have taken a vow not to indulge or tolerate or allow any sort of discrimination which you can imagine and comes within in your mind. But in spite of this constitutional mandate, it is slightly alarming that we time and again have to deliberate, discuss, ponder, interact and find out what is the status of discrimination, whether it is racial, whether it is the gender, whether it is on the basis of religion, caste, group, affiliation. This to my mind comes out that in spite of we still feel that there is some aberration in implementation of these laws, and this is I'm glad that the judges from the most important country of the Commonwealth has participated and have given us the pleasure to know their experience while they are dealing in the courts, and also the Indian counterpart, as to what is their experience in dealing with such cases. And this afternoon session is especially devoted to the experience in the Delhi High Court and the Gujarat High Court, the two most important organs, our state high courts, and which is many a times in the news for its treatment of that subject. So I call upon the learned participants, and first of all the Honorable Chief Justice of the Gujarat High Court, the celebrated Chief Justice, Honorable S.J. Mukhopadhyay, to share is it so? To share his experience on the about this equality and non-discrimination decisions, and we are looking forward to share his information and experience in discharge of his official duty which he might have encountered. And of course we are looking forward to some improvement in our insight in treatment of the subject.
Good afternoon to all of you. In fact, I will not be going and limiting it within the two high courts, because some discrimination after my coming over here, because I was asked to deliberate on different high courts. Now I have been limited to two high courts, but I will be going for one high court, because in India we cannot ignore one or other courts. Since morning we are talking of equality and non-discrimination. But I think the main object is the equality. Non-discrimination is one of the tools. Now, discrimination is the ground if inequality is there. In the morning we discussed various facets, and the concept of equality in the context of Indian Constitution and Indian society, but also in Article 15 to 18 of the Constitution of India. This inequality and equality concept was looked into by different courts from different angles. The question was raised in the first half, and that I will be going on, that direct and indirect discrimination. I'll be adding to it on the basis of the decisions of different courts that there are protective discriminations which have been dealt with by different high courts, which has been also said as compensatory discrimination. That is in the context of the Indian society. Now if you talk of a caste,
In European society, there may be, one may not go for this caste and what is the difference between the one caste and the other caste. Absolute equality there is not among human beings. It is a matter of common sense that you cannot treat caste, scheduled tribe is a part of constitutional scheme of social and economic justice to integrate them into the national mainstream so as to establish an integral and social order with equal dignity, technical rule in favor of a party. What I am saying that equality is our aim. Non-discrimination is a tool, but in certain cases, the discrimination, if it is beneficial, that is also required. The Patna High Court there also dealt with the distributive justice system. There are certain things which equality, the framers of constitution introduced Article 17, a policy of untouchability. Article 18 prohibits conferment of military or academic distinction and acceptance of titles from foreign state except with the consent of the President. Now, Article 15 was dealt with by Madras High Court, and there it held, though Article 14 recognizes a general or constitutional equality among all human beings, some distinction, some classification, some gradation, if one has to reconcile constitutional or legal equality with the facts of life and needs of public administration, the whole system of the state taxation, particularly income tax, rests on a classification or differentiation of citizens according to their income and capacity to pay. The insane and feeble-minded persons might be put in a special class or category by themselves. The full bench of the Madras High Court further held that the guarantee of equality before law and equal protection of law given to the citizens by Article 14 of Constitution does not require that absolutely the same rules shall apply to all. The plain meaning of this plain enactment is that the state shall not make distinction between one citizen and another on the ground of his caste, race or religion. The significance of the word only is illegal or irrational. Article 15 of the Constitution, this is the Calcutta High Court in the case of Madam View. Article 15 of the Constitution provides inter alia, the state shall in favor of other. But inherent in the very notion of the every discrimination is a measure of comparison. The language used in Article 15(1) of the Constitution, discriminate against, should in my view be understood in the above light. The Gujarat High Court should not allow itself to be guided by extraneous or irrelevant considerations, since that would itself amount to denial of equality. The Supreme Court held in the case of the International Airport Authority that principle of reasonableness and rationality, which is legally as well as philosophically, as ascertaining the meaning of and content of these expressions. All are equal before the law and are entitled without discrimination to equal protection of the law. We need to have constraint by the interpretation placed upon them in the other countries, though the relevance is undoubtedly great.
Thank you. Thanks a lot, Chief Justice, for your analytical reading of the subject, its manifestation, and I guess even I have added to my information when you have said about compensatory discrimination and protective discrimination. And it was a pleasure listening to you, but I was only getting apprehensive that I might not be indulging in discrimination by giving more time to you and less time to the other speakers. So I was a bit apprehensive about the time, but it was wonderful listening to you. But while listening and also while deliberating on the subject, I was just wondering that we have read so much about this subject. We, day in and day out, we deal with cases regarding equality, non-discrimination. But do we really need such a long thesis and a long vision to come to a conclusion as to what is discrimination? If we were to give a Gantian solution, the most simplistic form of a solution dealing with equality and non-discrimination, first of all, we have to introspect and find out and the answer would come not less than a minute that yes, this is discrimination. So what I feel is that when we deal with discrimination, most of the time we justify discrimination. We know that this is discrimination, but we want to justify discrimination, and that is how the laws on discrimination requires its treatment, its application, and that is how the courts or any tribunal or arbitrator comes into the play. So most of the time, I think we need to impress upon how to stop this instinct that when we know it is a discrimination, when we know that somebody is indulging in discrimination, when we know that it is not going to suit us, then we try to fight it out and justify that no, this is right and what I'm doing is correct. I think judges often we do face, especially when we deal with cases and arguments, hearing both the sides, that no, you are wrong in this and this way. And it's only in the form of justification which comes from the other side that no, it is not discrimination and I'm right in such and such way. But of course, how to curb that justification is really a subject which needs to be addressed to. Thank you so much, Chief Justice.
Can I just ask one question?
Yeah, sure.
It's just the only chance I may have to ask the question. I listened with astonishment when I learned that under Indian law, you cannot have cases, I understand it, where there are combined factors. Suppose you have an Asian woman who doesn't know whether she's discriminated against because she's Asian, or because she's brown, or because she's a woman. A classic example in England. In England, we don't have to say it has to be only on the ground that she's a woman, or only on the ground of her ethnicity. It can be a combination of those, and indeed the new Act says so. Is your law so narrow that you cannot have a combined characteristics case?
Subject to, if it is shown that it is not reasonable. In any case, it is shown that combining together, we are talking of Article 15. One may say it is arbitrary, violative of Article 14, being unreasonable. But nobody can say it is violative of Article 15. Article 15 has a distinction from Article 14. The Article 15 talks of only on the ground of race, etc. But coupled with that, it may be unreasonable, then it will be violative of Article 14 of the Constitution, not 15.
I think one of the illustration may be when I had an occasion to deal with a case where women were claiming the absorption in the permanent commission in the Army and the Air Force, where the question arose as to whether this is a reasonable restriction. So, if the as I have been able to understand is that if you have the discrimination, as I again use the expression justified, it can be justified on the ground of reasonableness, then it ceases to be a discrimination. But that question is the moot question which most of the time the courts have to address. Whether this is reasonable to do this, whether it is reasonable to put a check, whether it is reasonable to put a curb. Supposing an old, aged and a destitute woman is, restrained from traveling in just a very crude example, traveling in a train, because that might interfere with the free flow of the people at general public, then there are two views possible. And when there are two views possible, then the courts and I mean the arguments and the analysis, the citations needs to be supplemented as to whether this is reasonable or not. So I think Chief Justice appears, of course I can't pass any judgment over here, but I guess if we can supplement our view with reasonableness, then it ceases to be discrimination, whether it is the domestic law and I guess the laws abroad also. I now call upon one of the very eminent judge of the Delhi High Court, Honorable Justice A.K. Sikri, who doesn't need any introduction insofar as the High Courts here are concerned, but I take this opportunity to say that Justice Sikri is one of the eminent judge who has demonstrated from his judgments and his treatment that discrimination in any form has to be dealt with an iron hand. And I remember in cases of pensionary benefit where the discrimination is meted out by the state, that you have retired such and such year, so this will not be, this benefit will not be given to you, and the other class will be given. If I remember correctly, I think he has dealt with this subject in a very, it's a lot of elucidation and a lot of reasoning which could give food for thought and supplement and assist the concept of reasonableness. I now call upon Justice Sikri to address us on the subject of equality and non-discrimination so that we can further benefit from his views.
Thank you, Honorable Ms. Justice Kyansuvat Mishra, and thanks for your kind words as well. My colleagues from other high courts, Mr. Gonzalez, his team, honorable judges from other jurisdictions, ladies and gentlemen. I have two introductory remarks before I start with the main theme. One is, if I say in a lighter vein, when Justice Mishra said that the two judges, Chief Justice Mukhopadhyay and me, would be giving the case, because that is the topic that the High Court decisions, and we will be confining to our High Courts. I take it as mandate under Article 141, and so I said in a lighter vein, because I have prepared in this manner. I thought that there are judges from all over India, from various high courts. So naturally all judges would be giving the presentations relating to the judgments of their high court. So that is how I had prepared, and I also understood in the same manner.
Just for a second, I would like to add, I think this mandate is not under Article 141, but it is the mandate of the organization which gives out as to what is the topic of today's session.
That's right.
I think the change is there.
No, it's all right. I just said that I am confining, therefore I thought that I will be highlighting the judgments of Delhi High Court. And the second is that I may not be limiting my discussion to the doctrinal approach to the equality and reasonableness, etc. And ultimately, as the topic suggests, the aim is to achieve equality and to remove non-discrimination, as in the introductory remarks Honorable Justice Mishra pointed out, and in that direction what should be and what is the approach of the courts to achieve that. So maybe it will be amalgam of these things. Then when we talk of, as far as my second aspect is concerned, so therefore I would, what I propose and to give, lay the foundation to that, I may be starting, say, somewhat jurisprudentially, giving the foundation of this equality concept and how I want to develop thereupon. I mean, the idea is just to do justice. That is what we are supposed to do as judges and any judicial system anywhere in the world. And justice, of course, it has alluded what justice is. And therefore, here I'm not going to say much about that. But one thing which is clear is that justice is core value not in the field of theology, law, political philosophy, but in politics, social life, and economics. When justice is the core value here, I would say equality is the core value of justice. And if you see the thinkers, political thinkers and jurists, I think most of the definitions of justice, it is all founded on equality. And in the manner in which it is founded, I wanted to highlight that. Aristotle opined that treating all equal things equal and all unequal things unequal amounts to justice. Then Kant also said that you should treat others as you would want everybody to treat everybody else, including yourself. So these were, of course, traditional views, and in post-traditional liberal democratic theories of justice. Now here the background assumption in all these, if we go to the recent in last few hundred years, how the concept of justice has developed, the background assumption is that all humans have equal value and should therefore be treated as equal as well as by equal laws. And this is what is described as reflective equilibrium, which was first introduced by Nelson Goodman in his book Fact, Fiction and Forecast in the year 1955. And John Rawls elaborated thereupon by introducing the concept of justice as fairness. And we know all, because why I'm developing that when I come to the judicial approach which a judge should have. So therefore the Rawls says justice as fairness, and thereafter Hume, actually he has come out with a very interesting theory, and he says that why injustice prevails or why inequality prevails. Says that nature has not given sufficient to the mankind, and on the other hand, on the one hand there is a scarcity of goods, and on the other hand human propensity for avarice. So this leads to the a battle where people want to grab, and when one wants to have more of it, then it results in unequal treatment to the other. And therefore, in his he evolved the theory of distributive justice, where the justice aims at achieving a society producing maximum happiness or net satisfaction. So when I look into these concepts of justice based on equality given by various jurists, say, and as in modern times, Rawls' notion of justice as fairness, and Hume's distributive justice, to which Indian people know, and I think others would also be knowing about our Nobel laureate Professor Amrita Sen. He has also subscribed to this. If you read his writings, he's a Nobel laureate who won this Nobel Prize in Economics. Then we get the jurisprudential basis of doing justice based on equality. Of course, when we talk of this equality, and we have our constitutional provision, we have our constitutional mandate about it, and Chief Justice Mukhopadhyay has said very elaborately all these things. But what I feel is that what is there, on the one hand we say yes, on that everybody has to be treated equally, then there has to be maximum good of all. But in reality, in this life, it doesn't happen. because of other reasons which I have explained. And it may be because of many social conditions of certain people everywhere, maybe, and particularly in Indian context I can say, but it may generally apply to others also, that we find the groups which are discriminated against, maybe women, scheduled caste and scheduled tribes in India, then children, aged persons, disabled persons, poor migrants, then that is immigrants, people living with HIV or AIDS, or sexual minorities. Why I am confining it to this, and most of the cases which Justice Mukhopadhyay also pointed out, the problems relate to these people. And it is because of the social conditions in each country, or particularly, I mean, if I say with reference to India, Justice Karju, Judge of the Supreme Court, he had given his address on the topic significance of human rights and its correlation with judicial functioning. There he said, in today's India, human rights and justice can have no other meaning than providing every man and woman in the society with food, water, and other necessities, employment with reasonable income, medical care for her family, good education to the children, opportunities for further development of personality and skills, housing, recreating and rest, old age and sickness benefits. To my mind, any other meaning given to the word justice and human rights is only empty talk and devoid of real worth or content. And the conditions which prevail and why inequality results and how it is to be eradicated. If I give simple example, take the case that poverty. I mean, we know that in a country like India, where more than 30% people live below poverty line. Now, it itself raises to so many issues of equality and discrimination. Now, because of poverty, a person is not able to have education. His right to education, we have those kinds of issues in our country. Now, the constitutional amendment is, there's a constitutional amendment saying that up to the age of 14, a child has fundamental right to receive education. But then, problem arises how he gets admission in the schools. And when I develop on that, there are case law when we say about equality and how these issues are dealt with and have come up before the court. And right to food, we know Supreme Court judgment where directions were given to the government in the beginning that you have surplus wheat and why don't you give it to those persons who are hungry. Then we have problem of unemployment, medical care. Now, one example if I give here itself, and Mr. Gonzalez had filed that public interest litigation in Delhi High Court, where